Good morning. Okay, so we're doing a potential new filing when a person has a claim pending before the Appeals Council. And as some of you might know, but probably many do not, you can't file generally a new claim when you are taking your old claim to the Appeals Council. After the Appeals Council denies you, then you can file a new claim at the same time as appealing to the next level, which would be the federal district court. Okay. So the general rule of not being able to file a new claim while you have the one you just had and got denied on by an ALJ, now before the appeals council, that came about. I really want to find what year it was, but it was early on. I'm thinking it was like 2010-ish. I think it was under the Obama administration when they didn't let that happen anymore. And it was a real difficulty because sometimes the appeals council, you appeal to the appeals council, you could be waiting for a year and you don't have a new claim. You can't even pursue. You're just like sitting there with your thumb up something and there's nothing you can do. I think the reasoning for it, ostensibly, and it would be saving, I suppose, money. They were saying two people are working on what could potentially be an overlapped claim to begin with. This is true. Because they would be having on the new claim, the whole initial and recon getting, that's money, manpower, blah, blah, blah. So they really stop people from filing for new claims if they had that old one. Because if the old one at appeals council gets granted, meaning probably a remand back to the judge for a new hearing, then he will be looking at that old period that he denied you on to seeing if he needs to reverse himself all the way to the present. So he'd be going through the time period before you got denied, so your whole case time period and anything that you retroactively claimed, and all the time period after he denied you to the present. So there would be an overlapping. So I get the monetary issue, and I'm a big one about saving money. Don't spend it where you don't need to. But I think the hardship might outweigh that on claimants because we already have claimants who are disabled, or at least believe they are to be, under the rules. You know how the rules are like you have to be very disabled, not just unable to do your old job and you can't think of another job you can do. Like that's not it. But certainly 99.9%, and I'm making up that number, are very impaired, whether or not they rise to the level of full, all 12,000 jobs are not doable. And the stress and the strain and in their own subjective mind, at the very least, and oftentimes actually so, they can't work, they can't make ends meet. And that wait at the appeals council is incredibly frustrating because you're not allowed to pursue. Now, perhaps a video for another day is while you're at appeals council, what should you be doing? Oh, there's plenty I could tell you about what you should be doing. I'm an A, B, and C girl. If you're working on A, you better be working on B and C. Those are the options you'll be taking if A fails you. There's no room here in your life to go slacky and just put all your eggs in option number A, because oftentimes option number A is not going to work. I'd say I don't know what the overall percentage is, but maybe half the people, option A isn't going to work. So if you had option number B, it might not be as full-blown robust as A, but it'll still get you where you need to be. And then possibly C. So anyway, so let's go through this. This is DI 12045.027. New claim or appeal filed while a prior claim or appeal is pending before the Appeals Council. This is for Title II or Title 16. Now, I might not be going through the whole thing, but it's important to know that there are some, and it's kind of complicated. There are some exceptions when you still can file a new claim, but it's not the general way and it's not generally permissible, but there are exceptions. So let's see if we can get into this. They say under the introduction at that page, and I will link this in the comments below. And this section is designed to provide the field offices with instructions for processing a new claim or appeal when a request for review is pending before the appeals council. They are told to follow the procedures noted below if the prior claim, the one you have at the appeals council, is for a different title. So what does that mean? If you had an SSD case and you never filed for SSI, you could file an SSI claim. If the shoe fits, it might be that when you filed your SSD, you were not poor enough. You still had savings that you hadn't spent yet on living, because you just became disabled. It could be, let's see, you are still insured, but now that you are a few years out, your DLI, we have playlists on that, folks. Very, very important to know your DLI. Your DLI is now in the past. You are no longer insured for SSD. So any new claim would never be for SSD because in that new time period, you're not even insured. You haven't bought the insurance in years because you haven't been working. And as you know, the only way to buy the insurance is to pay it through your FICA taxes, whether you're self-employed or a W-2. Okay. So you can file if it's a different period. This would also be true if you had an SSI claim you appealed and it's pending before the appeals council. And now let's say you weren't insured before when you filed for the SSI, but since then you've been working very part-time under SGA. It doesn't interfere with your claim for SSI, but it also gains you those very valuable Social Security credits that will get you insured status for Social Security. I love it when people do this because I just love to see people not on SSI and going for, having their own insurance that they can claim as their own because they bought it. So if that is the case, you could file an SSD claim while your SSI claim is pending at appeals council. All right, so the next thing they mention is if it's for the same title, but for a different benefit type. For example, claimant wants to file a new Title II disabled widow or widower's benefit application, and the claimant has a claim pending for Title II disability insurance benefits. Okay, so, and this is pretty cool. You had a disability claim, SSD. You got denied, you appealed to appeals council. It's sitting there. You since, sadly, unfortunately, become a widow. As a widow, if you are disabled and if your spouse was insured for Social Security, say retirement, he was already vested and everything, I think, you can now put in a new claim for the widow's benefits, which would come from the time that you became the widow, assuming you filed kind of in real time, because it doesn't go fully retro if you waited 3 years, but you would still argue it probably. You can now file for disabled widow benefits because now you are a disabled widow, which you weren't before when you filed for SSD while your spouse is still alive. Now your spouse has passed. And so that's a whole different benefit under the Title II program. Title II was Social Security, retirement, disability, survivors, etc. Okay. If the prior claim that is before the appeals council, this is the third thing on the list, guys, is a continuing disability review, you can file a new claim while that's pending. That's very cool. If your appealed prior claim that's sitting before the appeals council was on an EXR, expedited reinstatement claim, that generally occurs when you are denied due to earning too much money and your benefits stopped and you appeal that stoppage. You can file a new while that appeal, if it goes all the way to appeals council, is pending. The second to last one on the list, if the prior claim, which is now sitting before the appeals council because you were denied at ALJ hearing, was for an age 18 redetermination, you can file a new at that time too. What an age 18 redetermination generally is when a child was on SSI because of his own disability. Remember, children can't get Social Security disability based on their own disability, but they can get SSI if they and their family are poor enough. So at age 18, generally, they redetermine whether you are still disabled under the rules now for adults. you were disabled as a child, which has different rules, different, criteria because children don't work. So you can't use the work-related rules. So if you are getting redetermined for an age 18 redetermination, and that's sitting, and you've been denied, and you're sitting at ALJ, I'm sorry, Appeals Council pending status, you can file a new for SSI. At which case, by the way, just to toss this in there, if one of your parents were disabled or retired or deceased, you might then also be filing for DAC because you already have proof that you were disabled before the age of 18, which is clearly before the age 22. Okay, last but not least, if the prior claim is now pending before the Appeals Council because you were denied at ALJ, you can file a new claim if that prior one was a remand from federal court to the AC level. So that's pretty interesting too. I hadn't really thought about that last one. I don't think I see those, but we tend to win our remand, so maybe that's why. Anyway, okay. There is something here that says, okay, and this is just a big, I guess, highlighted part. Do not accept or process a new disability application if the claimant has a prior disability claim for the same title and benefit pending at any level of administrative review. See procedural change, blah, 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 blah. Okay, I'm just listing those out. I'm not going to go any further because this is getting a little lengthy, but those are the examples where you can file a new application. It doesn't apply to most of us, but it applies to, it's not rare either. So anyway, keep that information on board and I will talk to you guys later. God bless and have a great week. Bye.